Yes. Anyone online? David C. Njoku. DV and Enabeli. Anyone online?
Yes, my lord.
Yes. Parties absent. Announce your appearance.
With profound respect, my lord, I am Dr.
Yes.
Victor N. Enabeli. Dr. Victor N. Enabeli, my lord.
Yes.
My lord, I appear for the defendants in this matter. I'm so
Yes.
sorry, my network has been terrible. So sorry about that.
Yes. Anyone for the claimant? David.
Hello.
Call him whether it is network.
My lord, I have just gotten a message from Dr. David Njoko. He said he can hear us, but it appears we can't hear him.
All right.
Yes, my lord.
Okay, so he's online. All right. Dr. David.
Yes, my lord, he's online.
Yes. For the claimants. The matter is for judgment and is ready. So I will proceed to read the judgment.
We're most grateful.
This suit was commenced by the claimants via a complaint filed on the 5th day of June 2025, pursuant to Order 3, Rule 1, Sub 1A and Sub 2, 1, 8, 9, 10, and 11 of the National Industrial Code of Nigeria Civil Procedure Rules 2017. The originating processes filed by the claimants include the complaint, statement of facts, affidavit of verification, list of witnesses, witness statement on oath, and list of documents. The claimant claims against the defendants jointly and severally as follows. A declaration that the termination of the claimant's employment with the defendants is unlawful and wrongful. B, an order directing the defendants to reinstate the claimant into service. C. The order directing the defendants to pay the sum of 7,808,339 naira 31 kobo, being end of service payment due to the claimant. D. An order directing the defendants to pay 10% interest on the sum of 7,808,339 naira 31 kobo until same is liquidated. E. An order directing the defendants to refund the sum of 770,100 naira, being medical bills incurred in Abuja, repairs and replacements of Toyota Highlander rear axle, and medical bills of 3 family members. F. An order directing the defendants to replace a Fijo 206 2007 model saloon car or pay the sum of 10 million naira, being its monetary equivalent as pledged by the first defendant. G. General damages in the sum of 5 million naira for trauma suffered and injury to reputation, and special damages in the sum of 1,500,000 for trauma and family distress. H. An order directing the defendant to pay the claimant the sum of 1,500,000, being cost of this suit. The defendants filed their statement of defense denying the claimant's claim and contending that the claimant's dismissal was justified for gross misconduct. Alongside the statement of defense, the defendants filed their list of witnesses, witness statement on oath, and list of documents. The matter proceeded to trial with the claimants testifying as CW1 and defendants calling one witness, Mr. Oladipo Emmanuel, as DW1. Both parties tendered documents exhibits in support of their respective cases. Parties' cases. This is based on your pleadings. I summarized the parties' case on the pleadings, so you will see it in the copy of judgment.
As the court pleases.
I will go straight to the issues for determination.
As the court pleases.
Having carefully considered the pleadings, the evidence adduced, and the submissions of both parties, this court identified the following issues for determination: whether the dismissal of the claimant from the employment of the second defendant was wrongful or lawful and contrary to the contract of employment and principles of natural justice. 2, whether the claimant has proved the allegation of breach of duty by the defendants regarding medical care, reimbursement of expenses, and alleged pledge to replace his vehicle. 3, whether the defendants have established gross misconduct on the part of the claimant sufficient to justify his summary dismissal. 4, whether the claimant is entitled to the relief sought, including the end of service benefits, general and special damages, and interest. I also summarized the parties' argument as a canvas in your respective final written addresses. It is also reproduced here. Then I will go straight to the decision of the court. The facts of this case are largely not in dispute. The claimant was employed by the second defendant as a software engineer and later became head of software service and security operations. His employment was summarily terminated on the 5th January 2025 following allegations of gross misconduct arising from procurement of laptops that were said to be fairly used and not conforming to specifications. The central issue is whether the defendants had justifiable grounds to summarily dismiss the claimant without affording him a fair hearing, and whether the claimant is entitled to the various reliefs he seeks. The evidence before this court consists of the following: claimant's Exhibit C1, offer of employment; Exhibit C2, letter of dismissal; Exhibit C3, confirmation of returns of company property; Exhibit C4, end of service entitlement; Exhibit C5, part payment received for suit dated 25th April 2025. While defendants tendered the following exhibit: Exhibit D1, letter of demand for return of company properties, Exhibit D2, letter of apology from the claimant, Exhibit D3, update on security procedures. CW1, the claimant testified and was cross-examined, while the defendant called one Mr. Oladipo Emmanuel as DW1, who testified and was also cross-examined. Now I proceed to resolve the issues for determination. On issue 1, whether the dismissal of the claimant was wrongful, unlawful, and contrary to contract of employment and principles of natural justice. The law is well settled that for a summary dismissal to be justified, the employer must prove the allegations of gross misconduct against the employee. The burden of proof lies on the employer to establish the grounds for dismissal. See Abubakar versus BOAP Nigeria Limited, citations provided, and the Chevron Nigeria Limited versus Ero Museli. In the instant case, the defendants allege that the claimant engaged in gross misconduct by procuring fairly used and inferior laptops instead of brand new HP laptops as instructed, thereby defrauding the company. However, the evidence before this court does not support this allegation. DW1 admitted under cross-examination that the stories in his witness deposition were stories told to him by someone else. The email he relied on were not before the court. The claimant was not the direct purchaser of the laptop, but acted through a third party. The claimant's employment benefits have not been paid to him. These admissions by the defendant's own witness are significant. They demonstrate that the defendant's case against the claimant was based on hearsay rather than direct evidence. The law is clear that hearsay evidence is inadmissible and cannot form the basis of a decision affecting a person's right. See MC4 versus UAC, Ayimbe versus State, all citations provided. Furthermore, the defendant failed to follow the principle of natural justice. It is strict law that an employee must be given a fair hearing before being dismissed. The claimant was not issued a query, was not given the opportunity to respond to the allegations, and was not afforded a disciplinary hearing. The dismissal letter dated 5th January 2025, Exhibit C2, merely states that the dismissal was following an internal investigation and subsequent review by management, without specifying the details of the investigation or giving the claimant any opportunity to defend himself. The Supreme Court in Garuba versus Kwara Investment Company Limited held that failure to observe the principle of natural justice in termination of employment renders the termination null and void. Similarly, in Idarinina versus Rivers State Civil Service Commission, all citations provided, the court held that an employee must be given an opportunity to be heard before the termination of his employment. The defendant's contention that the claimant had apologized for previous misconducts and had previously admitted to security lapses does not justify the current dismissal. The previous incidents were addressed by the defendants, and the claimant was allowed to continue in employment. The defendants cannot now rely on past incidents to justify a dismissal for a different allegation. I find that the defendants have failed to prove the allegations of gross misconduct against the claimant. The dismissal was therefore wrongful and unlawful. This issue is resolved in favor of the claimant. On issue 2, whether the claimant has proved the allegation of breach of duty by the defendants regarding medical care, reimbursement of expenses, and the alleged pledge to replace his vehicle. The claimant alleged that the defendants failed to pay his medical bills amounting to 289,500 naira for his family and 320,000 for treatment in Abuja. However, the evidence reveals several challenges with this claim. First, the claimant admitted under cross-examination that he was aware there was a limit to the company's medical coverage. The defendants established that the claimant was enrolled in the company's HMO scheme with NMD medical care, and that the claimant was at liberty to use any hospital of his choice, but would bear the cost himself. Secondly, the claimant's trip to Abuja was not approved by the defendants. DW1 testified that the trip was not approved and the claimant provided no evidence of approval. An employer cannot be held liable for expenses incurred on an unapproved trip. Thirdly, the claimant did not provide receipts for the allegations for the alleged medical expenses. The burden of proof lies on the party asserting a fact to prove it. See Section 131 sub 1 of the Evidence Act 2011. The claimant failed to tender the receipts for the medical bills he claimed to have incurred. I find that the claimant has not proved the allegations regarding medical care by credible evidence. On the reimbursement of vehicle expenses, the claimant alleged that he spent $330,000 to repair the rear end of the Toyota Highlander assigned to him. But the defendants refused to reimburse him. However, the claimant admitted under cross-examination that the mechanic who repaired the vehicle was not the designated company mechanic. It is settled law that an employee who disregards internal procedure and incurred expenses unilaterally cannot shift the burden to this employer. See ApriBank Nigeria PLC versus Osusanya. Citations provided. Furthermore, DW1 testified that the claimant took the vehicle to Warri without approval, which was outside the scope of his employment. The claimant did not provide evidence to rebut this testimony. I find that the claimant has not proved his entitlement to reimbursement of vehicle repairs expenses. On issue of Peugeot 206, the claimant alleged that the first defendant undertook to repair his Peugeot 206 vehicle from his previous employment. However, the claimant provided no documentary evidence, no witnesses, and no written undertaking to support his claim. The defendant denied this allegation, stating that at no point did any of the defendants or its management pledge or undertake to repair any vehicle for the claimant. The law is clear that he who asserts must prove. See Section 131 sub 1 of the Evidence Act 2011 and Okeke versus Okeke. The claimant has failed to discharge this burden. I find that the claimant has not proved the alleged pledge to replace vehicle. This issue is resolved in favor of the defendant except for medical expenses in Abuja, which the claimant also failed to prove. Issue 3, whether the defendants have established gross misconduct on the part of the claimant sufficient to justify his summary dismissal. Gross misconduct has been defined as a conduct which is so grave that it undermines the fundamental basis of the employment relationship and makes it impossible for the employer to continue with the employment. See Unity Bank PLC versus Buhari and the FBN PLC versus Oko. The defendants allege that the claimant unfairly used an Imperial laptop instead of brand new HP laptop, failing to disclose the defects to the company, conniving with the supplier to make profit from the transaction, refusing to return company properties valued at $7,900,000. However, the evidence before this court falls short of proving these allegations. Sorry. The claimant was instructed to purchase 150 brand new HP laptops and software materials. The claimant contacted suppliers and the laptops were supplied. When the laptops were delivered, some were discovered to be fairly used. The claimant testified that he immediately called the supplier, who admitted his mistake and replaced the laptops. This testimony was not effectively challenged. DW1 admitted that the claimant was not the direct purchaser of this laptop, but acted through a third party. This undermines the defendant's allegation that the claimant connived with the supplier. Furthermore, the supplier apologized to the defendant and negotiated the supply of the specific HP laptop. The claimant admitted under cross-examination that he did not inform his employees about the defect immediately, stating that he stated that I quote, focus myself in resolving the issue, unquote. While this might not be the best approach, it does not amount to gross misconduct warranting summary dismissal, especially given that the issue was resolved. The defendants allege that the claimant refused to return company properties valued at $7,900,000. However, Exhibit C3, confirmation of return of company property dated 22nd March 2024, contradicts this allegation. The claimant confirmed in that document that he has returned all items issued to him during the course of his employment, including company laptop and accessories, official ID card, and other equipments. The defendants claim that the claimant is still in possession of company's property is not supported by credible evidence. The defendant's witness simply asserted the value of the properties without proving any documentary evidence or inventory. The test for summary dismissal is that the misconduct must be so grave as to warrant immediate termination. See Chevron Nigeria Limited versus Eromo Selling. I find that the defendants have failed to establish any such misconduct. This issue is resolved in favor of the claimant. On issue 4, whether the claimant is entitled to the relief sought. On relief A, declaration of wrongful termination. Having found that the dismissal was wrongful and unlawful, I hereby grant this relief. The termination of the claimant's employment by the second defendant on 5th January 2025 is declared wrongful and unlawful.
As the court pleases.
Relief B, reinstatement. Reinstatement is a discretionary remedy. The court must consider the circumstances of the case and whether it will be appropriate to impose an employee on an unwilling employer. See Osaku versus Federal College of Education, Asaba. Citations provided. In the instant case, the relationship between parties has clearly broken down irretrievably. The defendants have expressed no desire to have the claimant back in their employment. The allegations and counter allegations have created a hostile environment. It will not be in the interest of justice to order reinstatement. However, the claimant is entitled to compensation in lieu of reinstatement. The court will consider the claimant's length of service and the circumstances of the dismissal. On relief C, end of service payment. The claimant claims 7,808,339 naira 31 kobo as end of service entitlement. However, the evidence in support of this claim is thin. The claimant only tendered a computation document, Exhibit C4, prepared by himself without any supporting documents or expert evidence. The defendants did not accept the calculations and contested the entitlement. The claimant's contract of employment, Exhibit C1, does not provide for end of service benefits or gratuity in specific terms. The claimant did not point to any provision of his contract or any company policy that entitles him to the amount claimed. Furthermore, the claimant's own Exhibit C4 shows deductions for unreturned property, which contradicts his Exhibit C3, wherein he claimed to have returned all properties. In the absence of evidence of the specific terms regarding end of service benefits, I am unable to award the sum claimed. it is strict law that a party claiming a specific sum must prove the basis for the claim. See Nigerian Port Authority versus Contract Resources Nigeria Limited. On relief D, 10% interest. Since I have not granted relief C, this relief fails. On relief E, refund of 770,100 naira. This claim comprises medical bills, vehicle repairs, and family medical expenses. For the reasons stated in issue 2, the claimant has not proved this claim. This relief also failed. On relief F, replacement of Figure 206 or 10 million naira. The claimant has not proved the alleged pledge by the first defendant. This relief also fails. Relief G, general and special damage. The claimant claims 5 million naira as general damage for trauma and injury to reputation, and the 1 million naira as 1,500,000 naira as special damage. The claimant alleged that the wrongful dismissal caused him hypertension and arrhythmia. However, he admitted under cross-examination that hypertension can arise from multiple factors unrelated to dismissal. He did not present medical evidence establishing a causal nexus between the dismissal and his health condition. The medical report, which was not tendered as evidence, is insufficient to establish causation. The law requires that damages for personal injury must be proved by credible medical evidence. See Ojo versus Garoro and Dangote Flour Mills Limited versus Aliyu, all citations provided. However, the claimant is entitled to some compensation for the wrongful dismissal. The Supreme Court is in Organ and Others versus Nigeria Liquefied Natural Gas Limited and another held that an employee whose dismissal is wrongful is entitled to damages. I will award the claimant damages in lieu of reinstatement, taking into account his length of service, about 3 years and 10 months, and the circumstances of the case. On relief H, cost of suit, the claimant is entitled to cost. I will award cost in his favor. In conclusion, this court finds that the claimant has proved that his dismissal was wrongful and unlawful, having been done without justifiable cause and without affording him a fair hearing. However, the claimant has not proved the specific monetary claims he made, including the end of service benefit, reimbursement of expenses, and damages for personal injuries. Based on the foregoing, this court makes the following orders. 1, a declaration is hereby granted that the termination of the claimant's employment by the second defendant on 5th January 2025 was wrongful and unlawful. 2, an order is hereby made directing the defendant to pay the claimant the sum of 2 million naira as damages in lieu of reinstatement, being compensation for the wrongful and unlawful dismissal. An order is hereby made directing the defendant to pay the claimant. 3, an order is hereby made directing the defendants to pay the claimant the sum of 1 million naira as cost of this suit. 4, an order is hereby made directing the claimant to return all company properties in his possession to the second defendant within 14 days of this judgment, failing which the defendants may take appropriate legal action. 5, all other reliefs of the claimants are hereby dismissed for lack of proof. 6, the defendant shall pay the judgment sum within 30 days of this judgment, failing which the claimant shall be entitled to recover same with interest at the rate of 10% per annum from the date of this judgment until final liquidation. This is the judgment of the court.
As the court pleases.
As the court pleases. My Lord, this is Dr. David C. Njoko, my Lord, and we are very grateful for the claimant. Yes, I'm sure my Lord can hear me now.
Yes, I can hear you.
Okay, my Lord.
I was already informed that you can hear us, but we cannot hear you. But
yes, my Lord.
I'm glad that now you can hear us.
Yes,
we can hear
Lord.
You.
Yes, thank you so much, my Lord. We appreciate
you
this
nice, restful weekend.
Thank you, my Lord. And we wish my Lord all the best too.
All right.
We're
Thank
most
you.
grateful, my lord.
By Monday, I may not be around on Monday, but I am sure by Wednesday you will get your copies of judgment.
As the court pleases. We are most
It
grateful,
will
my
be
lord.
ready. Yes, we are having light issues. They will have printed it, but I am sure by Wednesday, wherever I am, I will send a copy, and they will release certified true copy from before the statutory period of 7 days.
As the court pleases. We are most grateful, my lord.
I'm most grateful.
Okay.
Thank you, my lord. My lord, we beg to take our leave, my lord.
Yes, you can.